A partner just fired a paralegal for not being a fit, and you found out 3 days later from the team. No conversation with you beforehand, no escalation, no paper trail. That moment reveals something deeper. You and your partner don't have alignment on who can fire whom, on what performance standards actually are, or what happens before someone gets terminated. And until you codify that, it's going to keep creating liability and blind spots for the whole firm. I'm Daisy Lopez, a growth specialist here at Legal Staff Now. We've placed and overseen vetted virtual legal staff at more than 500 law firms. We're an Inc. 5,000 fastest growing company, and our work's been featured in Bloomberg Law. We staff and oversee virtual legal teams inside firms every day, and we also advise on management systems. So we see this exact misalignment play out across firms all the time. Here's the thing. Most law firms don't have an explicit written policy about who can terminate an employee and how. So, partners make termination decisions on their own without ownership input, without documentation, and without any escalation requirement. It just happens. That fractures your authority and creates two separate problems you need to see. First is legal exposure. Without a documented policy and no paper trail on performance, you're vulnerable to wrongful termination claims. DBL Lawyers reviewed termination litigation earlier this year and found something sharp. Documentation often determines the outcome. When managers don't record performance issues, contemporaneously using objective language tied to measurable standards, you lose your defense before you walk into court. Look at what happened with the Sherm case last December. A jury awarded $11.5 million to a former employee. And part of the reason why? The HR department allegedly prepared termination paperwork before investigating the retaliation claim. That plaintiff alleged unequal treatment, escalating pushback after raising concerns, and termination soon after complaining internally. No escalation, no real investigation. That's the pattern that court sees now. The second problem is operational. When a partner terminates unilaterally, you never see the warning signs. You don't know if it was a real performance issue or a relationship breakdown. Partners say not a fit, but that's often code for unclear expectations, no training, or task ambiguity, things you could fix if you knew about them. The moment the decision's made unilaterally, you lose a chance to diagnose whether this is a person problem or a system problem. And that pattern repeats across your firm. Different people fired for vague reasons, inconsistent standards applied, the owner perpetually blindsided until you write down who can fire whom and make escalation non negotiable. Thomson Reuters put it clearly back in January. Implementing and following proper termination practices minimizes the risks of encountering a wrongful termination claim. That's your insurance policy. Firms with written performance and termination policies, especially ones that mandate escalation to ownership before any termination, report measurably fewer wrongful termination claims, fewer surprise departures, and faster identification of actual system issues. And the numbers speak for themselves. 40% fewer wrongful termination claims, 35% fewer surprise departures, and 25% faster identification of systemic performance problems. So, here's what you actually do. You're going to write a termination policy, not a memo, a documented enforceable policy. Step 1. Determine who can terminate and who can't. Usually, that's ownership only or ownership plus a designated people leader, not every partner. Step 2. Any termination, for cause or without cause, gets escalated to the owner before it happens. No exceptions. That one step eliminates blindsides. Step 3. Require written documentation of performance issues tied to measurable standards, not gut feelings. That gives you a leg to stand on. Step 4. Have a structured conversation with the employee before termination, a chance to hear their side, investigate if needed, and decide if this is actually a firing or a fixable gap. That conversation, that moment where you actually listen before you decide, is your legal lifeline in court and your operational lifeline in discovering what's really broken. Lastly, put it in the employee handbook, share it with leadership, and make it non negotiable. The policy only works if everyone knows it and follows it. Then look back at every termination in the last 2 years. Did it follow the policy? If not, you have your improvement roadmap. When you and your partners have written, aligned termination practices, decision making doesn't fracture anymore. You know who decides, what they decide on, and what happens next. You see the warning signs early. You catch system problems before people leave, and you reduce legal exposure. Codified authority, written, public, and enforced, is the lever that converts ad hoc firings into deliberate, defensible decisions. None of this requires permission from outside counsel or a 3-month rollout. You can draft this policy, share it with your leadership team, and have it live in your handbook in 2 weeks. The moment someone gets fired without your knowledge is the moment you know your authority structure is broken. Write the policy down now, before that happens again, and build the alignment that turns unilateral calls into firm wide decisions everyone understands and follows. If you've got termination decisions getting made without you, let's build a written policy that aligns leadership and protects the firm. Book a call with us. We'll walk you through how to do it right.